Please like, share, and subscribe this video to support.
2 U.S. Code Subchapter 5, Miscellaneous Provisions. 2 U.S. Code Paragraph 1431, Exercise of Rulemaking Powers. The provisions of Sections 1302, B, 3, Section 1, 1381, L, and 1384, C, of this title are enacted. 1. As an exercise of the rulemaking power of the House of Representatives and the Senate, respectively, and as such they shall be considered as part of the rules of such House, respectively, and such rules shall supersede other rules only to the extent that they are inconsistent therewith, and 2. With full recognition of the constitutional right of either House to change such rules, so far as relating to such House, at any time, in the same manner, and to the same extent as in the case of any other rule of each House. 2 U.S. Code Paragraph 1432, Political Affiliation and Place of Residence. A. In general, it shall not be a violation of any provision of Section 1311 of this title to consider the 1. Party affiliation, 2. Domicile, or 3. Political compatibility with the employing office of an employee referred to in subsection B with respect to employment decisions. B. Employee defined. For purposes of subsection A, the term employee means 1. An employee on the staff of the leadership of the House of Representatives or the leadership of the Senate. 2. An employee on the staff of a committee or subcommittee of A. The House of Representatives, B. The Senate, or C. A joint committee of the Congress. 3. An employee on the staff of a member of the House of Representatives or on the staff of a senator. 4. An officer of the House of Representatives or the Senate or a congressional employee who is elected by the House of Representatives or Senate or is appointed by a member of the House of Representatives or by a senator. In addition, an employee described in paragraph 1, 2, or 3, or 5. An applicant for a position that is to be occupied by an individual described in any of paragraphs 1 through 4. 2 U.S. Code Paragraph 1433, Nondiscrimination Rules of House and Senate. The Select Committee on Ethics of the Senate and the Committee on Standards of Official Conduct of the House of Representatives retain full power, in accordance with the authority provided to them by the Senate and the House, with respect to the discipline of members, officers, and employees for violating rules of the Senate and the House on non-discrimination in employment. 2 U.S. Code Paragraph 1434, Judicial Branch Coverage Study. The Judicial Conference of the United States shall prepare a report for submission by the Chief Justice of the United States to the Congress on the application to the judicial branch of the federal government of 1. The Fair Labor Standards Act of 1938, 29 U.S.C. 201 etc. 2. Title VII of the Civil Rights Act of 1964, 42 U.S.C. 2000 etc. 3. The Americans with Disabilities Act of 1990, 42 U.S.C. 12101 etc. 4. The Age Discrimination in Employment Act of 1967, 29 U.S.C. 621 etc. 5. The Family and Medical Leave Act of 1993, 29 U.S.C. 2611 etc. 6. The Occupational Safety and Health Act of 1970, 29 U.S.C. 651 etc. 7. Chapter 71, relating to Federal Service Labor Management Relations, of Title V. 8. The Employee Polygraph Protection Act of 1988, 29 U.S.C. 2001 etc. 9. The Worker Adjustment and Retraining Notification Act, 29 U.S.C. 2101 etc. 10. The Rehabilitation Act of 1973, 29 U.S.C. 701 etc. And 11. Chapter 43, relating to Veterans' Employment and Reemployment, of Title 38. The report shall be submitted to Congress not later than December 31, 1996, and shall include any recommendations the Judicial Conference may have for legislation to provide to employees of the judicial branch the rights, protections, and procedures under the listed laws, including administrative and judicial relief, that are comparable to those available to employees of the legislative branch under subchapters 1 through 4 of this chapter. 2 U.S. Code Paragraph 1435, Savings Provisions. A. Transition provisions for employees of House of Representatives and of Senate. 1. Claims arising before effective date. If, as of the date on which Section 1311 of this title takes effect, an employee of the Senate or the House of Representatives has or could have requested counseling under Section 305 of the Government Employees' Rights Act of 1991 or Rule 51 of the House of Representatives, including counseling for alleged violations of family and medical leave rights under Title V of the Family and Medical Leave Act of 1993, the employee may complete or initiate and complete all procedures under the Government Employees' Rights Act of 1991 and Rule 51, and the provisions of that act and rule shall remain in effect with respect to, and provide the exclusive procedures for, those claims until the completion of all such procedures. 2. Claims arising between effective date and opening of office. If a claim by an employee of the Senate or House of Representatives arises under Section 1311 or 1312 of this title after the effective date of such sections, but before the opening of the office for receipt of requests for counseling or mediation under Sections 1402 and 1403 of this title, the provisions of the Government Employees' Rights Act of 1991 and Rule 51 of the House of Representatives relating to counseling and mediation shall remain in effect, and the employee may complete under that act or rule the requirements for counseling and mediation under Sections 1402 and 1403 of this title. If, after counseling and mediation is completed, the office has not yet opened for the filing of a timely complaint under Section 1405 of this title, the employee may elect A. To file a complaint under Section 307 of the Government Employees' Rights Act of 1991-1 or Rule 51 of the House of Representatives, and thereafter proceed exclusively under that act or rule, the provisions of which shall remain in effect until the completion of all proceedings in relation to the complaint, or B. To commence a civil action under Section 1408 of this title. 3. Section 1207A of this title. With respect to payments of awards and settlements relating to Senate employees under paragraph 1 of this subsection, Section 1207A of this title remains in effect. B. Transition provisions for employees of Architect of Capital. 1. Claims arising before effective date. If, as of the date on which Section 1311 of this title takes effect, an employee of the Architect of the Capital has or could have filed a charge or complaint regarding an alleged violation of Section 1831(e)(2) of this title, the employee may complete, or initiate and complete, all procedures under Section 1831(e) of this title, the provisions of which shall remain in effect with respect to, and provide the exclusive procedures for, that claim until the completion of all such procedures. 2. Claims arising between effective date and opening of office. If a claim by an employee of the Architect of the Capital arises under Section 1311 or 1312 of this title after the effective date of those provisions, but before the opening of the office for receipt of requests for counseling or mediation under Sections 1402 and 1403 of this title, the employee may satisfy the requirements for counseling and mediation by exhausting the requirements prescribed by the Architect of the Capital in accordance with Section 1831(e)(3) of this title. If, after exhaustion of those requirements, the office has not yet opened for the filing of a timely complaint under Section 1405 of this title, the employee may elect A. To file a charge with the General Accounting Office Personnel Appeals Board pursuant to Section 1831(e)(3) of this title, and thereafter proceed exclusively under Section 1831(e) of this title, the provisions of which shall remain in effect until the completion of all proceedings in relation to the charge, or B. To commence a civil action under Section 1408 of this title. C. Transition provision relating to matters other than employment under Section 12209 of Title 42. With respect to matters other than employment under Section 12209 of Title 42, the rights, protections, remedies, and procedures of Section 12209 of Title 42 shall remain in effect until Section 1331 of this title takes effect with respect to each of the entities covered by Section 12209 of Title 42. 2 U.S. Code Paragraph 1437. Sense of Senate regarding adoption of simplified and streamlined acquisition procedures for Senate acquisitions. It is the sense of the Senate that the Committee on Rules and Administration of the Senate should review the rules applicable to purchases by Senate offices to determine whether they are consistent with the acquisition simplification and streamlining laws enacted in the Federal Acquisition Streamlining Act of 1994, Public Law 103-355. 2 U.S. Code Paragraph 1437A. Training and education programs of employing offices. A. Requiring offices to develop and implement programs. Each employing office shall develop and implement a program to train and educate covered employees of the office in the rights and protections provided under this chapter, including the procedures available under Subchapter 4 to consider alleged violations of this chapter. B. Report to committees. 1. In general, not later than 45 days after the beginning of each Congress, beginning with the 117th Congress, each employing office shall submit a report to the Committee on House Administration of the House of Representatives and the Committee on Rules and Administration of the Senate on the implementation of the program required under subsection A. 2. Special rule for first report. Not later than 180 days after December 21, 2018. Each employing office shall submit the report described in paragraph 1 to the committees described in such paragraph. C. Exception for offices of Congress. This section does not apply to an employing office of the House of Representatives or an employing office of the Senate. 2 U.S. Code Paragraph 1437B. Support for out-of-area covered employees. A. In general, all covered employees whose location of employment is outside of the Washington, D.C. area, referred to in this section as out-of-area covered employees, shall have equitable access to the resources and services provided by the office and under this chapter as is provided to covered employees who work in the Washington, D.C. area. B. Office of Congressional Workplace Rights. The office shall 1. Establish a method by which out-of-area covered employees may communicate securely with the office, which shall include an option for real-time audiovisual communication, and 2. Provide guidance to employing offices regarding how each office can facilitate equitable access to the resources and services provided under this chapter for its out-of-area covered employees, including information regarding the communication methods described in paragraph 1. C. Employing offices. It is the sense of Congress that each employing office with out-of-area covered employees should use its best efforts to facilitate equitable access to the resources and services provided under this chapter for those employees. 2 U.S. Code Paragraph 1438. Severability. If any provision of this chapter or the application of such provision to any person or circumstance is held to be invalid, the remainder of this chapter and the application of the provisions of the remainder to any person or circumstance shall not be affected thereby.